Victims in the state of Alaska have a constitutional right to a timely disposition. Certainly, defendants also have a right to zealous advocacy and to have their case looked at and well handled by an attorney. So there's a balancing act that has to happen within the courts.
On July 4th, 2019, there was a felony assault against me. It was in the evening. I was left for dead. Okay? So that's essentially what this is all about, was that assault on me, which was a felony. And since then, it's been almost 3 years.
During the pandemic, Alaska's criminal justice system had to change the way it does business. Jury trials were suspended for more than a year. Inmates awaiting trial couldn't meet with their lawyers face-to-face. Criminal cases piled up, exacerbating an already growing caseload for too few prosecutors and attorneys.
We try to push it along. We don't really have any control over the judges or over the prosecutors or defense, but we try to raise the issue or encourage and empower victims to raise the issue and speak out. Trying to get the Anchorage Criminal Court, because it only happens in Anchorage, to quit doing off-record continuances, because they do that sort of in the dark of night, in the sense that there's no public record, that the lawyers get together and tell the judge, we want to continue this off record because we're not ready for trial anyway. Victims don't know about it. They show up at these hearings. It's been continued off record. It's something that shouldn't happen.
It's a victim's rights to participate in the criminal justice system. And so when we limit or create barriers to that participation, their rights are being denied. In the same way that when we think about treating all victims with dignity and respect, is their dignity and respect being served when there is no access to justice?
I don't mind reliving what happened to me. It was pretty gruesome. It definitely did impact my life. I have had to learn how to walk because my balance was impacted with a blow to my head. I've since learned how to breathe. I'm learning how to live with huge muscle spasms in my left neck and the shoulder, the midsection where the 8-inch incision was to check all of the intestines to see where I was bleeding out. And there'll always be the muscle spasms where the knife went in to the left side in the rib cage.
Growing up, Jackie would take us berry picking in the mountains, and I'm 43. She would have been about my age at that time, and she never broke a sweat, never showed any signs of fatigue. Just basic quality of life for somebody who grew up outside and harvested the fruits and land. Like, that ability is just completely eliminated.
I think the most infuriating part for me is just seeing her struggle with, for example, PTSD as a huge side effect of the attack, and how that has affected her relationships with everyone, including her grandchildren. It's hard to see her want to be around him, but also he can't have big sudden movements, especially on her left side.
Just learning how to get out of bed was a big major one. Not only being in survival mode, but having to learn a new way to live, because this is all new to me with my body. And I've always been physically active, and to go from that to nothing was too much. I think the reason I've survived, and I talked with my attorney about this, is that I've been strong enough physically to be able to withstand what happened to me. And I am articulate enough to be able to voice my opinion. And sometimes it will come across very harshly, but you know what? I'm done. I'm absolutely done. Something has to be revamped. In fact, the whole system needs to be revamped.
In 2018, 266 criminal cases went to trial, both felonies and misdemeanors. In 2019, it was nearly 320. Compare that to numbers in 2020, just 58, and last year, 92.
The legal system was absolutely spot on in the very beginning. You couldn't ask for a better team. The questions that were asked and the people that came in to help initially, that was all well and good, but it needed to be really taken care of very carefully, because a person who is under that much pain and trying to survive really cannot cooperate to a full extent. And for crying out loud, let's change this. Oh, we're going to put it on the docket for next week, because when you call in, it's with such anticipation that you know your case is going to be assigned to trial, and it doesn't happen. And this has gone on for far too long.
COVID did exacerbate the problem. No ands, ifs, or buts about it, right? It's like a clogged drain. It's just more stuff backed up. It wasn't moving well here in Anchorage before that. And the thing about COVID that frustrates the heck out of me, honestly, is while there were no trials going on, there's still plenty of work for defense attorneys and prosecutors to engage in working their cases, looking at discovery, finding out what's missing, filing motions, having hearings, doing all those things that are before the trial anyway. It's as if those all stopped too.
So in a non-pandemic sense, if you don't look at those factors, any criminal case, the whole idea is that there's a charge, there's been an accusation, the defendant has pled not guilty, he or she is asking for a trial. The attorneys on both sides have to prepare for that. They have to go through a very complex process of looking at what evidence is available, what is going to be admissible, what are the potential pretrial motions, were there any constitutional rights that were implicated, and depending on the nature of the case and the complexity of that, that can take sometimes, typically for a felony, that's going to take about 6 months, but it could easily take a couple years. That, if you're in the shoes of the victim, is painful because you're waiting. You've the whole reason you're there is because you've lost control of something that has happened to you. And now you're waiting and you have no control over that. It's a very difficult process, I think, for the victim. But with the pandemic, when you took away the trials, that had a very significant impact. Not necessarily that the lack of trials was holding back the resolution of many cases. It doesn't. Typically, only 1% of felony cases actually go to trial. Only 2.5% of misdemeanor cases actually resolve in trial. But there has to be that immediate possibility of a trial there. There's got to be that trial setting. That's when you see cases resolved. It seems like that decision process just accelerates once there's an actual trial on the horizon. And so when that got taken away, a lot of that pressure to resolve these cases got taken away. Most of the attorneys couldn't get access to witnesses to talk to them because they couldn't sit down and talk to them. They couldn't prepare their witnesses, and they had to do everything by the phone. Yet we're looking at a trial process that is a very visual medium where jurors are asked to look at and evaluate witnesses. On the defense side, the defense counsel, they had no access to their clients for a very long time.
There's been a ton of turnover in both the defense side and the prosecution side. So there are a significant number of attorneys in both of these offices, and I speak mostly in Anchorage, that have never been to trial because of COVID. There's a lot to learn, and there's a lot at stake for victims and the community.
To be able to resolve cases, you have to have some experience to evaluate the evidence of, do I have a strong case from the prosecution standpoint? Can I meet my burden to prove this beyond a reasonable doubt? That evaluation process got slowed down immensely because there was such a turnover. We lost so much experience off the criminal bar. And a new prosecutor needs some time to get a feel for, what's my opening going to be? What are my questions? What do I anticipate for cross? What's my closing going to be? On the defense side, it's just completely brand new. You just tear it completely down. It's like if you're doing a remodel of a home, you're tearing it all the way down, back down to the studs, and you're going to have to start putting up your drywall and then taping it and mudding it and doing all those things all over again, because you've got an ethical responsibility to review that case through your own eyes and then advise your client. All of those factors together, related to the pandemic, just exacerbated what already probably seems like a long delay anyway, especially if you're the victim waiting for this case to get resolved.
For 3 years, Jackie's been told she can't talk about this, can't talk about details. For victims who are already suffering the emotional trauma connected to the event, now have to suffer through the justice system, who's specifically telling them they cannot talk about their experience. She deserves that opportunity to publicly be able to move past this. And in Tlingit way of life, the way that we process and move emotion and grief and trauma is with human witness. We have specific ceremonies around public grieving where your opposites can hold you up through that. Our Western society is one generation of Jackie's life. Tlingit society, several generations. So she's feeling what she's going through, the motions of what she's been told she has to go through, but her DNA has to struggle through not being able to have human witness for this event to get that closure. And at this point in the process, at 3 years, I'm legitimately terrified that because of the amount of years that have been taken off of her life because of this assault, she may never see justice. And that is completely unacceptable.
Why is our system so overburdened that somebody who has 17 counts against them prior to assaulting my mother, and there's video footage and eyewitnesses? Like, why? I just don't understand. I am a big supporter of rehabilitation for inmates, but for him to be in a city jail pre-trial for this long is just insane. It's purgatory for them and purgatory for us as a family.
Now, I will say during COVID, it was very hard for like our office or other people, even prosecutors, to argue about the victim's right to timely disposition, because the defendant's right to a speedy trial had also been stopped, right? How can you say that the victim's right should be attended to and the defendant's right can't? I mean, fair is fair, right? But I think overall the courts are very sensitive, worried, and reasonably so, of what an appeals court might do.
Anytime a defendant is convicted, almost always it's appealed. And almost always there's going to be a much more cool, detached, objective review of were the defendant's rights observed or was there an error that was made. If there's an error that's made, then more likely that case is going to get, that conviction is going to get vacated, and the case is going to come back down, and now we're going to start all over again. Not only again, the second time. I mean, that's always part of what happens as a victim is that they've lived the real event, and now when they come back to trial, they've got to relive it again, which has always got to be traumatic. If there's a reversal, then they got to go through it yet again. There's reasonable timing, reasonable preparation, and I don't think that that should just get lumped into an unnecessary delay that has occurred. And I think that's probably an important part of this conversation of, is it a necessary delay or reasonable delay? Is there something being protected because of that in the long run? Or is it an unnecessary delay and we're just not getting the work done? I think we always, as judges, when I say we've always looked at, hey, this case is 3 years old. Okay, where are we, counsel? Where are we in this case? Why isn't this case? Why aren't you asking for us to set this for a trial date? What more needs to get done? Of course, the defense they're not obligated to tell us exactly what it is, but they do need to provide some explanation. We are pushing to prioritize it, saying this older case, all right, is something that needs to get prioritized, and we can't keep slipping in newer cases before it. This case has got to get the attention. We've got to get this thing set for trial.
There's always needs for more resources to be pushed in this direction, to allow that access, to allow that equality, to allow the opportunity for more people to be trained to do a better job, so it has better effects for defendants, for victims, for anybody in the community affected by the crimes.
I don't know what it's going to take to get the judicial system to the point where it isn't backlogged. And unfortunately, what happened in my instance is that the pandemic happened. But you can only use that excuse for so long. This is my life. This happened to me. I don't have closure yet, and I never will physically. This is what I have to live with until I drop dead. And the culture I come from, we have a support system in our opposite. I'm Ishkitan, which means I'm a frog clan from Taku River. My roots go way, way, way back. I know my family history. My daughter-in-law knows her history. My son knows our collective history. And we teach our children, and the opposites, whether you're raven or eagle, we support each other. We hold each other up. And in this instance, and Amanda did touch on it, how do we get the closure? How do we get to celebrate our life? How do we get to end things in a way that is supportive all the way around? Is within the state of Alaska, Lower 48, wherever there's an indigenous culture, they have a support group, they have a ceremony, they have a way of dealing with life and death and for being hurt. And I don't see this at all in our legal system. And if anything good comes out of this to help in the future, that's what I would love to see.